The next contract that we're going to learn is voidable contract. A voidable contract is a contract which is cancelable at the option of one party. You can cancel the contract. Is it logical? I mean, you enter into a contract and suddenly halfway you say, no, I don't want to continue with it, I cancel the contract. Do you think law will support such an act, support such a contract? Law will never support such a thing, because law says if you promise something to someone, you should honor it, you should meet it. You cannot cancel it midway. Let's say you order a carton of dresses from England. So the exporter there readies himself for the shipment. He gets all the shipment done, and suddenly he gets a call from you that you've cancelled the contract. Do you think that would be right? That won't be right. So you cannot cancel all the contracts, you can cancel them only in special circumstances, only in special situations. We'll discuss those situations, but let us first understand what is meant by voidable contract. How has law defined voidable contract? A voidable contract has been defined as a contract which is enforceable by law at the option of one party and not at the option of other party. Which means only one party has the option, has the right to enforce it or to stop it from being enforceable. The other party cannot enforce it, or the other party cannot get a right to stop it from being enforceable. There's only one party which can either continue with the contract or avoid the contract, stop the contract. Now, why does this one party get this right? We know that there are two parties in the contract, but why should only one party get this privilege, get this option, get this right to make the contract continue and make it remain valid? Or the second option is to stop the contract, to cancel the contract. Why should this party get this privilege? Let's see. When does the contract become voidable? This party gets this privilege because free consent in the contract was absent. What do you mean by free consent? Free consent is nothing but free acceptance. Acceptance free of any force, pressure, fraud, cheating. So, when the acceptance is given under pressure, given by force or under force, or it was given because the other party cheated or defrauded this party, in these cases we can say that the consent is not free. So when the free consent is absent, the contract becomes voidable. Now, when can you say that free consent is absent? Let's see. When would be free consent be said to absent? The answer is free consent would be absent if these following things are present. Free consent would said to be absent, it would be said to be absent when the following things are present. The first is coercion. Coercion means applying physical pressure. If you tell somebody at gunpoint that please hand over your flat to me or else I'll kill you. Wouldn't that person transfer the ownership of the flat in your name? He obviously will. Here you can say that a contract has been made wherein the ownership of the flat has been transferred. But do you think this contract has a valid acceptance? This contract has an acceptance which was freely made? Or do you think the acceptance was made under pressure? The acceptance was made under force. It obviously was made under force. It obviously was made under pressure. So such an acceptance is not regarded as a valid acceptance by law. And we can say that free consent was absent. Free consent was absent because coercion was present. Coercion means physical pressure. When you apply physical pressure on someone, you are said to have applied coercion. The second is undue influence. Now, what do you mean by undue influence? Undue means unnecessary, unwarranted. And what is influence? Influence means power to dominate, power to change the will. Now, many of us have a property to be influenced by people. Whatever they say, we tend to follow them. We tend to agree with them. Now, if we follow whatever they say, that means they have the power to convince us. They have the power to dominate our will. So when someone can dominate our will, we can say that we are influenced by that person. And under influence, if we enter into a contract, the contract would be said to be entered by undue influence. For example, if a spiritual guru asks his disciple that the disciple donates 10 lakhs to his ashram, won't the disciple donate? Because the disciple is under the influence of the spiritual guru. So he donates 10 lakhs. So do you think that is a valid thing? Just because spiritual guru knows whatever he tells his disciple they'll follow, he asks them for donation. Do you think that is correct? The law says that is not correct. If a person agrees or accepts to the other person's offer under the dominance, but please remember this dominance is not physical, it's a mental or a psychological dominance. The guru does not beat the disciple. The guru does not ask for donation at the gunpoint. The guru does not threaten his disciple, but he mentally or psychologically dominates his will. So undue influence is called as emotional or mental pressure. So if a contract is entered by a person after being under mental pressure or emotional pressure of someone else, we can say that free consent is absent because he is agreeing, because he is under influence of some other person. He is not agreeing freely. He is not applying his mind. So law says if undue influence is present, free consent is absent, and if free consent is absent, the contract will become voidable. Now it will become voidable at whose right? In first case, in the case of coercion, it will become voidable at the option of the aggrieved party. Who was the aggrieved party? who transferred the flat at gunpoint. So he can go to the court of law and say, I do not want to go ahead with this contract, I want to stop it here and I want my flat back. He has this option. He can cancel the contract. In the second case, the disciple can go to the court of law and say, I donated under the undue influence, so I want my money back. He is the aggrieved party here. So a contract which is entered into without free consent becomes cancelable at the option of one party. He gets the option. The third case is fraud. If I tell you this pen is an imported pen, I tell you the ink was made in Germany, the nib was made in US, the body was made in Japan, and it writes super smooth. You will be impressed and you will want to purchase this pen. I tell you that this pen will cost you rupees 1000 because it is important. But the fact of the matter was, I purchased it locally and it does not cost more than rupees 10. So what am I doing here? I am lying to you. I am cheating you. I am defrauding you. I am committing a fraud with you. A pen which is locally made for not more than rupees 10, I am presenting it as a foreign made pen and I am selling it to you for rupees 1000. I know for the fact that this is locally made. I am cheating you deliberately. I am very much aware of this fact that it is locally made, yet I am representing it as a foreign made pen. So this would be a case of fraud. And if there is fraud, the law says free consent is absent because the agreement, the acceptance here is induced by cheating, is induced by fraud. So the contract will become voidable at your option. You can go to the court of law and say, I want to cancel this contract. Or you have the option to keep it, continuing to keep it valid, wherein you keep the pen and I keep rupees 1000. So you have two options. Either you can continue the contract or you can cancel the contract. The next case is misrepresentation. Misrepresentation is almost similar to fraud, except for one thing. There's only one difference. In the same example where I am representing this pen as a foreign made pen, it will be a fraud if I know that this pen has been domestically manufactured. But consider that I do not know that this pen has been manufactured here only. But I say this pen has been manufactured in USA. And I believe in that fact. Even I do not know that it has been domestically manufactured. I believe that it has been manufactured in USA. This would be a case of misrepresentation. Even though I am not intentionally, deliberately trying to cheat you. But the problem is I myself believe in that fact. Yet the law says free consent is absent here because it was a case of misrepresentation. And when free consent is absent, the contract becomes voidable. That means it becomes cancelable at your option. And finally, we have mistake. Even when the contract is entered into on account of mistake, the law says free consent is absent. I wanted to sell my bike to you for rupees 15,000. You thought I am selling my car to you for rupees 15,000. Now this contract was entered into by mistake. I thought I was selling a bike, you thought you were purchasing a car. So there's definitely a mistake in the contract, and you have agreed assuming it to be a car. So there is a mistake. And when you have given your acceptance, it is not free. You gave your acceptance by mistake under the impression that you are purchasing a car for rupees 15,000. So law says there is no free consent here. However, please bear in your mind that even though because of mistake free consent is absent, it does not make the contract voidable. Mistake makes the contract void. So if these four are present, we can say that free consent is absent and the contract will become voidable. However, if there is mistake, we still can say that free consent is absent, but the contract will become void. It will not become voidable, but it will become void. So just to revise, what is a voidable contract? A contract which is cancelable at the option of one party is a voidable contract. I have broken this word into two. You can see that voidable can be broken into two as void and able. So this is a contract which has the ability to become void. This is a contract which has the potential to become void. Now it is not void. It will be void if you choose for it to become void. So you have that right, you have that option to make it void. So when you choose the option to cancel it, it becomes void, but it is valid right now.